So I technically do have it done. I just didn't.
No, you don't technically have anything done.
Okay, well, I didn't send it out.
Young lady, you may address other people that way. You better check yourself before you're addressing me that way.
Thank you, Your Honor.
Court calls the case of the people versus, is it Ina Johnson?
Assistant Public Defender Natalie Pate with an on behalf of Ayanna Johnson, who is approaching. Please state your name for the record, ma'am.
Ayanna Johnson.
Thank you, Your Honor. Today is the date and time that was originally set for sentencing. I have received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz. And
Buckle up, guys. Today we are going to witness a courtroom moment that escalates almost immediately. The judge wastes no time shutting down excuses, setting a strict tone from the very first seconds. The defendant tries to explain herself, but confidence quickly collapses under pressure as the court calls the case and establishes the serious nature of sentencing proceedings already in motion. This opening already signals that compliance issues will drive the entire hearing. From the very start, you can feel the imbalance of authority in the room. Even minor interruptions are corrected instantly, showing zero tolerance from the bench. What seems like a routine sentencing quickly turns into a high-pressure situation. The tone is already tense before any real arguments even begin.
she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes. And they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at she does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Claire on behalf of probation. Your Honor, I did communicate with community corrections this morning.
The defense outlines sentencing status, but a clear pattern of misconditions emerges quickly. Alcohol screening and testing failures are placed on record, including a missed July 1st test. The defense requests an adjournment, citing employment concerns and need for more time, but the court is already focused on repeated non-compliance and growing accountability issues. The tension begins to build as a judge reviews prior warnings from earlier hearings. Each explanation from the defense sounds more like damage control than compliance. The judge is clearly tracking consistency, not excuses. Even small gaps in reporting begin to look significant in this context. The case starts shifting from explanation to scrutiny.
She did go over, and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing order.
Why?
Why what?
Why'd you miss a test?
Probation testimony deepens a situation as compliance records are reviewed in detail. Scram monitoring shows no direct violations, but reporting gaps raise serious concerns. The court learns the defendant has not checked in since mid-June, despite prior warnings issued months earlier. This creates a clear narrative of repeated oversight failures and weak follow-through on court-ordered conditions. The judge is now dealing with a pattern, not a single mistake. Every new detail adds weight against the defendant. Even without active violations, the lack of communication is treated as serious. The courtroom tone becomes more investigative and conversational.
Yes. I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yep.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh, they do so much. I mean, I didn't send you the last time. I'll re-refer to defendant Tuvon Swartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want to.
Paper?
What?
The paper?
What
All
paper?
the lists on it? What is Von Schwartz?
That's for your alcohol screening and assessment.
Is there somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out.
The judge takes direct control of questioning, shifting the hearing into a confrontational tone. The defendant is pressed on why testing was missed, but responses appear uncertain and unconvincing. Prior warnings from April are brought back into focus, highlighting that compliance was clearly explained earlier. The courtroom atmosphere tightens as frustration builds over repeated failure to follow instructions. The defendant's explanations do not reduce pressure. Instead, they intensify it. Silence and hesitation begin to work against her. The judge's patience visibly narrows as responsibility is emphasized again. It becomes clear the court expects accountability, not confusion.
My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant's remanded. Yes, go. Is that Dan?
Yes, Your Honor.
Get her back. Hang on one second. Go ahead, take her back. Come on up, Tito. Can you come up to the phone? What's your name, sir?
As questioning intensifies, the defendant admits to forgetting key steps, including alcohol screening requirements. The judge responds firmly, emphasizing that continued failure could result in maximum sentencing exposure. The explanation of assessment procedures is clarified in detail, but confusion only highlights lack of preparation. Responsibility is framed as unavoidable, and the court makes clear that delays and misunderstandings will not excuse noncompliance. The judge's tone shifts into warning mode, not guidance. Every answer now carries consequences. The courtroom energy feels increasingly final. What started as explanation now becomes a formal caution.
Tony Johnson.
Okay. Can you help try to get her through the, I mean,
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I
she
know,
need this job so bad.
I know. And I, trust me, I did not want to. I just, Miss Polara, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is. So that he knows what she has to do.
Yes, Your
So
Honor, and I do know, I heard him in the hallway, really getting after her for not doing things. So I think that he will.
Well, I don't doubt
If
that.
you stop by my office, or I'll ask them to give you the paper printed out.
Is that in this
It's
building?
right down the hallway,
Okay.
and so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.
Whose case is this? Yours?
Yes, Your Honor.
Counsel approach with.
The court outlined formal obligations again, stressing miscompliance steps and unpaid requirements. The defendant remains out of compliance, leaving the judge increasingly limited in options. A strong warning is issued that continued failure could lead to maximum sentencing. The tone becomes final and procedural, signaling that leniency is nearly exhausted as the court prepares to make a decisive ruling. The judge is essentially mapping out consequences step by step. There is no ambiguity left in expectations. Every missed requirement narrows the path forward. The atmosphere suggests a decision is imminent.
Miss Blair. Recalls the case of People versus Johnson. Didn't he just tell you to take your hands out of your pocket? Oh.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Johnson. Ms. Johnson, please state your name for the record.
Ayana Johnson.
Miss Johnson, let me ask you this. Do you want to go to jail?
No.
So I'm going to tell you what. The only reason I brought you back out and didn't have you sent down is you can thank that man right there, your dad. Because if he hadn't stood up and said something to me, I would not be letting you even thinking about letting you go. There is no reason in the world you haven't gotten this done. None. Do you hear me?
Yes.
When your dad found out that you didn't do this stuff, what did he say to you?
He said they not playing with
The judge issues a shocking decision ordering a 3-day county jail remand for the bond violation. Court staff immediately moved to enforce the ruling, marking a sudden escalation in consequences. The atmosphere shifts sharply as the defendant is taken into custody process. Family members react emotionally, signaling the real-life impact of the court's decision and the seriousness of repeated noncompliance. The shift from discussion to enforcement is immediate and firm. No further arguments are entertained. The room transitions from hearing to action. It becomes a clear turning point in the case.
you should have been had it done. Stuff like that. There's no reason that you shouldn't have it done.
And what, you don't think he was right to?
Yeah.
So why didn't you have it done?
Because I didn't check my email to have it printed out. When I got the call from her that I needed to have it done, I printed it out. I just need to send it out. I have the money order. It's literally in the car, in the envelope. I just need to mail it. So I technically do have it done. I just didn't send
No,
it.
you don't technically have anything done.
Okay, well, I didn't send it out.
The young lady, you may address other people that way. You better check yourself before you're addressing me that way.
I'm just saying, I didn't get a chance to send it out.
Because you know what? Your daddy's right about one thing. I'm not playing. Are we clear?
Yes.
The defendant's father steps forward, attempting to intervene and explain the situation to the court. He expresses concern about his daughter's future and job stability, asking for leniency. The judge allows limited discussion but maintains authority over the decision. Financial obligations and documentation are addressed, adding another layer of responsibility and pressure in an already emotionally charged courtroom environment. The father's presence introduces emotional weight into the legal process. However, sympathy does not override compliance issues. The court balances humanity with accountability. The situation becomes both personal and procedural at once.
Now tell me why I ought to give in to your father's wishes to let his daughter go.
Because I have to go to work. And because what I did was minor, and I'll fill it out and send it out. So you should let me go so that I can go to work so I don't lose my job.
Were you thinking about that when you didn't mail the envelope? Did you think about all the bad stuff that could happen to you?
No, not really.
If you lose your job, what are you going to do?
I'm going to have to figure it out.
Are you in school?
I was the summer school right now,
Where?
pathways.
So you trying to get your high school education?
Yes,
How old are you?
20.
How close are you to getting your, are you going to get a GED or a diploma?
My diploma. I have to go back in August for like 2 months, and that's it.
And then what?
I have to go back for 2 months, and that's it.
And then you have your diploma?
The defendant is brought back into court for direct questioning, where the judge asks a blunt question about whether she wants to go to jail. She admits to mistakes and acknowledges she should have complied earlier. The judge highlights her father's influence in the decision to give her another chance, but makes it clear that this opportunity comes with strict expectations and zero tolerance for further failure. The tone here is final warning territory. Responsibility is fully placed on the defendant. Any further slip will not be excused. The judge makes it clear this is her last meaningful chance.
Dad, is there anything you want to say?
Do everything in my power to make sure all this gets done.
Father's prayer for his daughter. I'm going to tell you what, young lady. Miss Blair, a condition of her release once we get through this is that she gets her diploma.
I noted it already.
Thank you. Your dad says he has the $75. I want that paid today out front. You have to pay your father back.
Okay.
You hear me? Dad, you'll promise me if I let her go that if she doesn't pay you back, you'll let me know? I'm going to cancel my remand. I'm going to give you a warning. I can be just as straight up as I can be with you. You mess anything up, even that man's not going to be able to save you. You hear me? Go with her dad. Dad, thank you.
Thank you very much, Your Honor. And I do apologize. What was the adjourned sentencing date again?
The adjourned sentencing date on this matter will be August 28th.
Thank you very much, Your Honor.
In the final stage, the defendant explains missteps and job concerns, but the judge rejects excuses and reinforces accountability. The court shifts to education and employment context, but maintains strict expectations. The earlier remand is reduced to a final warning, with conditions set and sentencing scheduled for August 28th. The outcome reflects a last chance situation where any further mistake could trigger immediate consequences. The judge closes a loop by reinforcing structure and deadlines. The defendant walks away with conditional freedom, not relief. Everything now depends on strict compliance going forward. One more failure could change everything instantly. Thanks for watching. Make sure to like the video and subscribe to the channel, and we'll see you in the next video.